Hi, this is our adventure into the justice system of R versus Jordan in a charter challenge. In September 2022, my wife received a traffic ticket for just over $550. We thought it wasn't justified and we wanted to fight it. The trial date was set for November of 2022. We had a family friend who was a lawyer, and when he heard the details, he was outraged and said that he would represent us. At the November trial, he requested discovery, which meant that the Crown would supply us with the evidence of the charges. This would be the 3 witness statements, the body cam videos of the 2 attending police officers, the dash cam video of the attending police vehicle, and the police reports of the 2 attending officers. At this point, it wasn't a trial but became a rescheduling hearing. The judge adjourned the trial to October 2024. As the months went by, our lawyer friend informed us that it was starting to use up a lot of his time and that he would have to start charging us. He said that it would end up around $8,000 by the time it went to trial. We decided that it was not worth paying that much to fight a $550 ticket, and we would represent ourselves. Which brings us to the old saying, a man who is his own lawyer has a fool for a client. Well, my wife and I are both retired with lots of time on our side and felt that we didn't have anything to lose at this point. The ticket was unjustified in our eyes and worth the risk, and the whole principle of the thing. We again went to trial in October 24 and representing ourselves, and while waiting in casual conversation, we had learned we could make a charter challenge to have the charges dismissed due to the length of time from when we were charged until the time of the trial. At the October 2024 trial, we informed the judge that the Crown had not provided us with complete disclosure, and we were missing the body cam video and the police report from the second officer, and also we were missing the dash cam video. Based on the incomplete discovery, the judge adjourned the trial until January 2025. At this point, we naively asked the judge that we would like to make a charter challenge and have the ticket dismissed. The judge informed us that traffic court is provincial court and he doesn't have the authority, and we would have to make a charter challenge in federal court. Now, I must say I am not a lawyer, and I'm only documenting the process that we went through to make a charter challenge in the hopes that it will help someone else who is trying to go down this path. To be honest, we didn't really know what it meant to make a charter challenge. After a few hours of research, we found that the Canadian Charter of Rights has Section 11B, trial within a reasonable time. It states any person charged with an offence has the right to be tried within a reasonable time. So I guess the question is, what is a reasonable time? The Supreme Court of Canada in R versus Jordan in 2016 made a ruling that defined what a reasonable time would be. It is often referred to as the Jordan decision and sometimes a Jordan application. Basically, the Jordan decision states that from the time you are charged to the time of the trial should be less than 18 months for provincial courts and 30 months for federal court. Anything larger than these limits, the defendant can apply for the case to be dismissed because it violates their Charter of Rights. Traffic court is a provincial court, and while it is only a traffic ticket, traffic court still meets both the requirements for the Canadian Charter of Rights Section 11B trial within a reasonable time and the Jordan decision. We received our traffic ticket in September 22nd, and our trial is scheduled for January 2025. Roughly 28 months after being charged. The trials on October 2022 and November 2024 were not trials but rescheduling hearings due to the discovery requests. We obviously met the criteria for the Jordan decision. I spent weeks researching how to make a charter challenge in federal court in Alberta and found out it is called a Jordan application. There is little to no information on the process. It felt like it was purposely vague to discourage applications of the law. During this time, we had been receiving bits and pieces of discovery from the Crown. In Alberta, you go to traffictickets.alberta.ca, log in with your ticket number, and go to traffictickets.alberta.ca/disclosure-details to check if any evidence had been uploaded. So we spent a lot of time, over 2 years, checking to see if any evidence was uploaded. This was the time frame of the disclosure. Original charge was September 22nd. On April 2024, 18 months after, we got our first disclosure, which was the collision report, witnesses 2 and 3 statements. On May 2024, 19 months later, after the charge, we got witness number 1 statement. On October 2024, 24 months after the charge, Officer 1, we got a redacted body cam video. October 2024, 24 months after, we got Officer 2 notes. In January of 2025, 28 months later, was our trial. I came across Ontario Supreme Court, R versus Frail, 2017, paragraph 44. It states that the Crown cannot fail to meet its obligation to make timely disclosure and then attempt to attribute the ensuing delay to the defense for failing to do without material it ought to have received. So from the above timeline, it shows that the Crown failed to provide timely discovery, and the delay would still count towards the Jordan decision of 18 months limit. So now that we had legal precedents, we could move forward. To make a charter challenge, you start by filling out a CC-1 form. This is an Alberta form you download. The first section is called the court file number, and this was interesting. The court file number uses your traffic ticket. I thought that was kind of a great way of tying the court documents together. The accused, that would be the person whose name is on the traffic ticket, which was my wife. The application by, I had that as my wife because she was the legal representative and who was going to represent herself in court. You'd put your address, the contact information. Normally this would be a lawyer's info, but it was our contact info. Notice to the respondents, this part is filled out by the court clerk as they schedule the trial date and judge. On the second page, it has a thing called remedy sought. In our case, it was dismissal of charges for the ticket. We weren't sure what to put in, so we went super specific, added a lot of detail in the reference to the Charter of Rights. Grounds for making this application. This is in point form, breaking each step down with detail, starting with the length of time being unreasonable, that the length of time violates our Charter of Rights, that the length of time exceeds R versus Jordan limit of 18 months, and that any delay by the Crown to provide discovery does not infringe on our right to a speedy trial based on R versus Frail. The material relied on. This refers to the attached and marked, in this case my wife's name, affidavit. The affidavit is a sworn document that will contain all the evidence that you will be presenting to the court. The affidavit is the heart of your legal argument. Applicable rules, Supreme Court of Canada Jordan decision, this is the main ruling. Applicable acts and regulations, list the Charter of Rights, section 11B, R versus Jordan and R versus Frail. I'm thinking that maybe the last two should be under applicable rules because it's kind of a ruling. I don't know. Next, you have to start with an affidavit. The affidavit is a sworn document that contains all the evidence that we'll be presenting to the court. So on the first page, you have a court file number, which is our traffic ticket number. The court, it's the Court of King's Bench of Alberta. Judicial Center, this was a pull-down menu when we were in Calgary. Accused contact info and affidavit, so basically my wife's name and contact information again. And then you have to swear on these documents. So any documents that are presented to the court must be sworn in front of a Justice of a Peace, Commissioner of Oaths, Notary Public, lawyers, professionals. We went to a Commissioner of Oaths, and it wasn't that expensive. It was about $150 for the affidavit and the exhibits. Page 2, my wife swore under oath that the following statements are true. Remember that we are only arguing the length of time to the trial. We are not arguing about the merits of the ticket. Whether we deserve the ticket or not is just noise to the judge and would work against us if mentioned. This was actually hard to get out of our head because we're only looking at the delay. We wanted to present the statements in the most logical and easiest form for the judge to read and follow. Affidavit page 2, the following information is in numbered point form and stating facts. It has to be numbered. Each numbered line states one and only fact. The first identifies who we are and that we had intimate knowledge of the circumstances. In this case was my wife. Each line is a factual statement. You can't use any lines that say I believe, I think, I feel statements. Your opinion does not matter. Subsequent lines begin with that, and then you talk about an exhibit, shows. All evidence is an exhibit that must be presented before being discussed. Each exhibit must be identified and be attached to the affidavit. Exhibits that are not court documents must have their source identified and time and date when they were obtained. Like Exhibit B ticket information disclosure was a screen capture from a website. The traffic ticket is a court document and doesn't have to be an exhibit, but to make it easier for the judge, we included it. Each item of disclosure by the Crown is presented and shown that it was readily available and the delay incurred since the charge. In our case, it was a red flag to the judge when it takes 18 months to get a copy of a readily available witness statement that was written on the day of the charge. Also, it was identified that 25 months after the charge, Officer 2 body cam and the police vehicle dash cam video were still not made available. Statements 2 to 11 present evidence to the court. Starting with Statement 12, we stated facts. The length of time of 28 months to trial is unreasonable and violates our charter rights. Statement 13 states that the 28-month period exceeds the limit for provincial trials ruled by the Supreme Court. On page 3, Statement 14 states the time to trial was due to the Crown's delay in providing discovery, and R v. Frail ruling states that the defense can't be blamed for the delay. Lastly, the affidavit must be sworn before a Commissioner of Oaths, a Justice of the Peace, lawyer, or student at law. Exhibits. An exhibit is a separate document to the affidavit and attached to it. Each exhibit should have a cover sheet clearly identifying it as an exhibit by letter and that it has been sworn before an official. In addition to the cover sheet, we marked each exhibit with the word exhibit and the appropriate letter. We created 4 packages, the sworn, original, and 3 copies. Our goal was to make the whole package as easy as possible for the judge to read. We bought binders, labeled them with sworn, original, or copy number, our case number, and contact information. The binders were divided into the following sections: Table of Contents, CC1, Affidavit Exhibit A, Exhibit B, etc. In addition, we added the pertinent sections of the rulings and law that applied. This was to convenience the judge, so he doesn't have to go look it up. It's right there. The filing has to be done a minimum of 2 weeks before the trial. The Charter of Challenge trial has to be done 6 weeks before our traffic ticket trial. We found that we had to go to the traffic court clerk. After consulting with his supervisor, came back and told us to go to a courtroom on the 10th floor. We arrived at the courtroom to find that it was a traffic court in session. And during a break, we identified ourselves to the court clerk and were told to wait until the end. The surprising part is that we were now scheduled to appear before a judge and present our application. We presented our sworn, original, and 3 copies. There were 3 court clerks reviewing our materials, stamping it received, adding them to the court records, and making sure that the copies matched the original. Once the material was documented, we stood before the judge, who was a provincial traffic court judge. We explained that we were applying for a charter challenge and a federal court trial date was set for early December 2024. We were given a trial date notice. Our challenge was finally filed. So now it's December 2024, and our trial date arrives, and we head to trial to the courtroom on the 10th floor. Outside the courtroom, it lists all of the trials by the defendant's name. Our name wasn't listed. We went in and talked to the court clerk, and the clerk couldn't find it in the system. Found out that the ticket had been dismissed and we hadn't been notified. We never found out why the ticket was dismissed. We can only speculate that the prosecutor realized that there was no way that they could win. The prosecutor superiors realized that it was costing a lot of money for a traffic ticket. Or maybe the federal judge read our brief and dismissed the case. Or that the federal judge looked at the charge and thought it was a waste of the federal court's time and dismissed the case. Regardless, the case was dismissed, and I'm pretty sure it had to do with our charter challenge. And thank you for watching.